Good afternoon and welcome to today's webinar. Today's topic, how to accelerate auto loan recovery success. I want to welcome everyone who joined us for part one last week and welcome people who are just joining for the first time for part two. For those of you who are joining just for part two, at the end of today's webinar, you'll receive an email with a link to part one if you wish to watch that one. We are excited to be partnering with DRNdata again on this topic. My name is Scott Weltman and I will be the moderator for today. I'm a shareholder at Weltman. For those of you who aren't familiar with Weltman, allow me to give you a brief overview. For over 90 years, Weltman focuses on all aspects of creditors' rights. We currently have 8 offices across 5 states. We represent nearly every type of creditor, including some of the largest financial institutions in the U.S. in bankruptcy, consumer and commercial collections, litigation, and real estate default matters. Before I get started, I have a few housekeeping items. I wanted to remind you that this is an interactive session, so please submit your questions through the question button in the control panel. Like last week, your questions will be addressed throughout the presentation where applicable. The webinar is being recorded, and after today's session, you'll receive a link to the recording for this session as well for all attendees. Please feel free to share that link with anyone on your team that may benefit from hearing the recording. Now I'd like to introduce today's panelists. I'm excited to be joined once again by the Executive Vice President and General Manager of DRNdata, Jeremiah Wheeler. Also joining from Weltman are David Head, Scott Fink, and Dave Tomer. Before we start the presentation, I'd like everyone to introduce themselves. We'll start with Jeremiah. Jeremiah, please introduce yourself and tell us a little about your company.
Hey, Scott, thanks for having me again. My name is Jeremiah Wheeler, and I'm the Executive Vice President and General Manager of DRNdata. We are a data and analytics company. We help people find people. We've been doing business for about 12 years in the financial services and auto finance space. We serve about 45% of the top 100 auto lenders out there, and we serve also another 350 plus customers across other segments of business. We help insurance agencies fight fraud, and we also help auto manufacturers find critical recall vehicles. So variety of different data sets that we have. Happy to be here. Look forward to talking with everybody and another good webinar.
Thanks, Jeremiah. I'll turn to the Weltman team now and start with Dave Tomer.
Thanks, Scott. I'm Dave Tomer. I'm the National Collections Director at Weltman. I'm responsible for the strategy and operations of our consumer collections division and have been for the past 18 years. For 25 or so years prior, I worked in consumer finance, managing default and servicing operations for financial services companies, including Chase and KeyBank. It's a pleasure to be with you all today. Back to you, Scott.
Thanks, Dave. And next we'll turn to Scott Fink.
Hello, everybody. My name is Scott Fink. I head up the firm's bankruptcy practice. We have a dedicated group of attorneys and support staff who focus solely on bankruptcy matters for our creditor clients. Been with the firm for about 16 years and been practicing for about 23, 24.
Excellent. Thanks a lot, Scott. And last is David Head. Go ahead, David.
Good afternoon, everyone, and thank you for joining today. My name is David Head. I'm the managing shareholder over our consumer practice group. I've been with the firm since 2003. As Scott indicated, both Scotts. I'm also a shareholder here, and I've practiced in this consumer field the entire time that I've worked here. We handle all lines of business, including what we're going to talk about today, auto deficiencies, as well as student loans, credit cards, unsecured loans, you name it in the consumer world, we are handling it here at Weltman. Thank you.
Thanks, David. So just to recap what we covered last week, last week we talked about recovering your collateral. DRNdata covered how you can use technology to locate your collateral, and then we talked about the decisioning around repossession, using a replevin, and of course the compliance steps you need to follow. After that step, and we're going to pick up today is you got your vehicle and or other, if it's a larger collateral, and you've sold your collateral, and now you have a deficiency balance. Today we want to focus on what it takes to collect that deficiency balance. We're going to get back on the road to recovery and guide you through that process through all 4 of our speakers. We're going to start first with Jeremiah Wheeler, and I'll start with the first question for Jeremiah and let him go from there. Jeremy, when does recovery start? What do people need to know about where it starts?
Yeah, so I guess it depends on the institution, first of all, whether you're talking about the actual lender that originated the debt, and then eventually it, went delinquent, they recovered the asset, they liquidated the asset, and we're sitting with a deficiency balance. In some cases, some lenders never sell their debt. They never sell deficiency balance debt, whereas in other cases, a number of lenders do sell deficiency balance debt to free up cash to continue to originate, continue to operate, and therefore they want to get rid of those bad debts off of their books. But the recovery process really starts immediately after everything's been settled as far as the asset being sold at auction. And in a case where a lender is sitting on a deficiency balance, they have to send out the legal notices of deficiency balance, and then they typically, if they're using our data and analytics, they will run some data on the customer to figure out where their last known address was. And if they're using their current account information, they'll want to verify where the car was picked up, because that's usually a pretty good indicator of where the customer may be. And they will go about it a variety of different ways. So they'll try to collect in phone calls and emails and letters, text messaging, variety of different services. But typically that recovery process is going to start immediately right thereafter of liquidating the asset.
That's great. So how can our clients improve their rate of collection?
Well, I mean, a lot of our customers are improving collections by looking at data and analytics a little bit differently. Traditionally, you have a few sets of data. You have the data that you have on file, which in most cases, if you recovered the asset, will still be somewhat accurate. It depends on the time frame as well. So if you have a transient borrower that moves a lot, and let's say you recover the asset, it takes 20 to 30 days to get it liquidated, to get the funds processed and everything back in the door, then that customer could have possibly moved again. So it's really important to understand the data that you have on file, if it still lines up with known data. In our case, obviously, we're still collecting license plate reads nationwide, and we're feeding that data to our end users and our customers to say, here's where that person is. By the way, they did go out and buy a new car after their old car got repossessed. They're now driving a new asset. We can tell you where they are, virtue of where they're parking that asset, and you can line that up with last known addresses, relatives, known associates, etc. And then you can say, okay, I have a good contact location to send a legal letter of collection, or make contact with a process server if I'm going legal, or call them on the phone, whatever your contact strategy is. But that's the way that they're improving their collections, because in the traditional sense, you would churn through a lot of these things for days and weeks, and in a lot of cases not get results because you're relying on old, outdated information. So I think the most important piece is to have the best, most accurate data that you can possibly have. And the way that we prove the value of accurate data is you can do historical lookbacks to say, I know where I contacted this customer, I know where I finally served them, I know where they ended up. Can you tell me what you would have told me back whenever I first started looking? And we can do retro analysis to tell customers, this is where we would have told you to go, this is who we would have told you to call. And then we can cross-correlate that data to make sure it makes sense for them to either, one, enter as a new customer, or enter a trial on our data analytics agreement, and move forward to prove then the value of the data thereafter. So there's a number of different ways, but that's some of the ways that our customers are actually improving collection rates right now.
Great. So obviously everybody has limited resources. And one thing that we know that everyone likes to do is prioritize where they put those resources. So what does DRN do to be able to help with prioritizing which debt to attack and to collect first?
Yeah, so there's a couple of different ways to look at it. There are customers that come to us and ask us to help them analyze one, portfolios they're looking to buy, or portfolios that they just purchased, or in some cases, if they've owned the portfolio for the entire life cycle, they come to us and say, can you help us score this group of customers from a risk-based standpoint? We want to know which ones have the highest propensity to skip, which ones have the highest propensity to collect. And so we have a variety of different ways that we score the data using the best known address, the best contact information, and all of that information is scored and analyzed against previous sightings, and also we can tell you whether or not it's, you know, residential or commercial, so it could be a place of employment or it could be where they live. We can break down all of those things. We can also tell you, you know, this is a residential address. We've seen the car here. We've seen them here a number of times over the past X days, and it's deliverable for mail, or we can tell them it's vacant. So there's a number of different ways to do it. But if you're looking at a portfolio and wanting to prioritize that, if it's a deficiency balance portfolio, you're going to want to know which ones to go after first, which ones have the highest propensity to connect and collect. And so it's very important that you hit that low-hanging fruit right off the top, because it can make a drastic difference in your overall cash flow coming back into your organization.
So last week we had a few questions. They got away from automobiles and onto questions like trucks, you know, commercial vehicles. And I was just curious whether you can expand upon that a little bit on the deficiency collection side. Is there a distinction that people should be making, you know, data they can get from DRN? What do you think about that?
Well, I mean, so from a commercial standpoint, we do have some customers that have commercial lines within their business that they use our data and analytics for. I would say our data portfolio holistically has gotten a lot stronger over the past few years as we've added more public records data into our LPR database, to where we are able to help people skip people more so than just skipping an asset. And so when you're looking at a person that may have, you know, financed the big rig, they also have a personal vehicle that they use on a daily basis. So if we can help you find that personal vehicle and where they're parking and where they're staying, then I think we can help you find that person to connect and collect. That makes sense.
Sure. And then, you know, we're about to get into the third-party collection process when we start talking to the Weltman team. Curious if you had thoughts about, you know, when a lender should transition from doing it themselves onto a third party when it comes to deficiencies.
I think it's all about internal efficiencies. I think it has to do with how many people you have working within your shop that you can actually put more and more accounts onto. I mean, that's where most, whether it be lenders or agencies or law firms, they look at shifting work around or shifting work over to a third party group. If they are getting overwhelmed, and let's just say you bought, you know, over the last 9 or 10 months or 2 years, you bought pretty deep in the subprime space to be more competitive with your lender peers, then you're probably going to have a higher default rate, and you're going to have a lot more accounts flowing into that bucket. So you're going to want to turn up some ancillary services or some outsourced vendors to help manage that volume for you. And I've seen it work very, very well when you partner with the right companies that can understand not only collecting on what type of paper you have, whether if it's auto or if it's credit card. There are agencies out there that specifically they do a much better job in some cases on credit card than they do auto. So you've got to find that really good auto shop that understands auto and that customer base in order to collect, and you can improve your efficiencies internally pretty drastically.
That's great. And then just the last question for you right now before we, as we go on and perhaps have questions later from the audience. I know last week you covered a little bit about the depth and the scope of your database and what percentage of the U.S. and so forth. And maybe for those that are new this week, you can just give a quick update on what you have in your database as people are interested in knowing more about DRN.
Yeah, sure. So on the license plate recognition side, so the cameras that are out there scanning and collecting license plate reads and location information, we have roughly about 6,000 sets of cameras out there collecting 215 million plate scans a month in about 390 markets nationwide. And since inception, which is roughly 11 years, we have about 16 to 17 billion license plate reads in the database. And then we're also integrating and pulling in a number of different public records data sets as well. So the database itself is drastically growing in scope and size to fit all of our customers' needs, regardless of whether they're auto or other types of unsecured debt.
That's great. Well, Jeremiah, I appreciate it. We're going to move to the Weltman team, and obviously you'll stick around, and we expect some questions if we have time at the end once we get to the next few speakers. So again, I appreciate your input. Next, we're going to have Dave Tomer join, and we sort of transition from what the creditor is doing to then working on collecting the deficiency balances. And again, I'll start with a question for Dave, which is how should companies be keeping track of the location of the loan signers once the collateral's been repossessed? What factors should they consider, post repossession?
Okay, I'll take that in two parts, right? So first, the tracking of signers post repossession, and I think as Jeremiah pointed out, right, it's important to maintain the tracking throughout the process to add value to the potential collection process, whether you're going to end up selling that portfolio or that loan or attempting to collect it internally. So I would start with the simple blocking and tackling that occurs on a day-to-day basis for most organizations internally, which would be gathering information from mail returns, national change of address, update scrubs, any internal skip tracing that's occurring, and making sure that that's kept current. And then, just the interactions between agents, whether they be customer service or collections, as you're talking to consumers, right? Just making sure that you're asking the appropriate questions to get the best contact information and address information, and maintaining that as you go as part of your normal process. On top of that, I would add, some of the stuff that Jeremiah pointed out, right? The information gathered during the repossession process, obviously in some cases we're searching for the consumer and the collateral. There's information that can be garnered from that, including where the vehicle was repossessed, and other information that Jeremiah pointed out related to that tracking. So that's fairly robust. What DRN provides is very robust. Additionally, the normal stuff that most organizations do around credit bureau tracking, triggers, those types of things that allow you to be aware when data is changing on a consumer, and keeping those updated within your system. Moving on to the factors to consider once collateral has been repossessed. I want to point out that we do quite a bit of auto deficiency collections here. And one of the things that always amazes me is the frequency with which the customers claim they're no longer liable or thought they were no longer liable, right? And whether that's a real thing or whether that's just the convenience of a statement to avoid discussion about the debt, at the end of the day, I think there's some validity there, whether that's because the consumer just quit opening the mail and didn't see the deficiency notice letter, or whatever other reason. So creating awareness around that particular item, that being that there may be a deficiency balance, I think there's value in looking at that and creating that awareness as early as possible within the context of the pre-repo process, where you're trying to get a cure and resolve a delinquency situation to avoid a repo. Probably a good place to start to talk about it, right? People understanding that there's a potential for a $10,000 debt when you're done, where you lost your vehicle and now have to continue to pay, and we do expect to be paid. That can be a motivational factor up front that changes their view on how they arrange their finances. If you're not successful there, though, certainly having that awareness going into the post-repo process and sale process is valuable to the overall collection expectations. In any case, whatever you're doing, things to consider once the collateral has been repossessed, aside from that awareness, is to retain the documents, right? And so it's really important that your organization retain good legible copies of the notices that are required throughout the process, including the rights to cure, repo sale notices, sale disposition notices, deficiency balance notices. They're going to be important for a number of reasons. First and and probably maybe least likely is addressing, a consumer or an attorney challenging your repo process, right? And saying that they don't believe it was done correctly. Secondly, those records, again, whether you're pursuing the loan internally or considering it for sale, having those documents available is going to change the value of the loan overall over time. So those are the things that I would consider.
Great. So obviously we know where our customer is, and we've spoken to them, and they're not interested in paying. What options exist for the creditors if the loan signer isn't going to voluntarily pay once they get a deficiency balance?
Well, so if we're talking about an internal effort, right? There's obviously, as Jeremiah pointed out, a potential sale effort, right? So I'll move into the third-party collection perspective and the internal collection perspective. So aside from the sale, an internal recovery effort could be a direction, right? And with that, just knowing the nature of the consumer at that point in time, or most consumers at that point in time, they've lost a vehicle, they've probably got a significant balance to pay. That internal effort should be as flexible as possible with any contact that you're able to garner from the consumer. Taking arrangements that they can afford for the near term and maybe making adjustments to those over time, or even aggressive settlements to be able to clear the debt from where they sit. In many cases, they're going to be looking for another vehicle and have other expenses. So really important that there's flexibility to manage those contacts as they occur. A number of our clients assign stuff to an agency immediately or after the internal recovery effort. So that's generally fairly cost effective. You're moving the inventory out of hand, but in many cases, and it really depends on the portfolio, the returns can be a little bit of a challenge. Another option is back to that internal effort is to maybe supplement the communications after attempts and no responses with a letter from a third party. So someone like us might step in, send a letter urging the signer to contact you as the lender to discuss resolution and getting a payment stream going. We found that to be fairly effective. And at the end of the day, it keeps that relationship with you and your customer. So if the signers remain uncooperative, unresponsive after all of those types of efforts, really litigation is the next option.
So follow up on something you said, which is aggressive settlement. And I guess this really applies while the creditor is still handling it in-house, applies once it's gone to a third party before litigation, and probably also litigation, which is, what factors do you recommend that creditors look at when deciding, what to settle for, what percentage to settle for, whether to settle? What are the key factors that need to go into that equation?
Well, the current situation is really the main factor, right? So separating situations where there may be a co-signer with a different ability to pay than the actual signer. I would say that individual's personal situation at the time is really where you want to focus, whether they're working, whether they have potential to work, assets available at the time. All of those, and I think most of the folks that operate in the recovery space have a pretty specific set of criteria that they're looking to in order to make those decisions. But the other side of it is, if settlement offers and the type you're talking about, require a contact. So the good news is if you're able to have contact with a consumer, not always the case, but when you are, I think you're in a position to gather the information that's critical to make a good determination as to the settlement amount.
Right. So you alluded to moving to the litigation phase, and generally, when should a decision go from the trying to collect without litigation and to the point where now it's time to file a lawsuit? What are those decision criteria you recommend?
I think, again, this is individualized kind of an approach to a degree, right? So if you're successful having contact, talking to somebody and, either coming to terms or understanding why they can't, that's one situation. However, for consumers who are not responsive or who are combative, right, uncooperative, I think that is a trigger, right? Consumers who issue a cease and desist as a ploy or a tactic may be ones to look at as well. But in general, I would say that, that over time, you would want to make that decision at least 12 months in advance of the tolling of the statute of limitations. And that's really just to say, hey, if you've got a viable consumer, you may find that through a score, you may find that through credit bureau information, you may find that through information that you've gathered. If you've got a viable account that could respond to litigation eventually, really getting that done 12 months prior to the tolling of the statute allows an organization like ours to review the information, review the documents, make sure everything that's needed is available, and get them into the litigation process prior to that tolling. So, but really, Scott, it's really situational per organization as to whether they have an internal recovery effort or not, if they have the analytics available at the point of the establishment of the deficiency to do that analysis. They may split off at charge off and push those accounts directly into the litigation process, or over time, once an internal effort has been waged or an internal agency effort has been applied, to come to the population that are pretty sure are not going to pay voluntarily.
So before I get to David Head and talk about the actual litigation process, I was hoping you could touch for a minute or two on some of the unique issues that auto lenders are going to deal with when their customer passes away. So, that unfortunately happens from time to time. They have customers who may or not be current at the time, and auto lenders are dealing with deceased customers. What are the issues they need to be concerned with and think about when it comes to their customers who pass away?
Yeah, so on an open loan, a performing loan, let's say, a number of organizations scrub their portfolios regularly to find decedents. Others respond to that information as it comes in, either through the collection process, through their customer service areas. And at the end of the day, a decision should be made when that notification or when that awareness is apparent, to whether or not they would like to search for an estate and file a claim or not, right? Basically, to protect the asset and protect whatever deficiency might exist afterward, it's important that a claim be filed into any open estate in a timely manner. And probate is a lot like bankruptcies. There are a statute of limitation on the ability to file those claims and have your claim accepted. So really, we recommend upon discovery of that date of death or the decedent, that the search for an estate be conducted immediately, and that if possible, a claim be filed. If that loan continues to perform forever, not a problem. You're covered within the estate for any balance that was on the claim. However, if that were to default and the decedent, obviously could no longer pay, once that liquidation occurs, once that deficiency balance has been established, you're in a position to restate that claim or reduce it to the deficiency balance amount and claim it against the estate and be paid if there are funds there to pay it.
And then, what's your experience on, filing a claim leading to actually recovering collateral on a loan that's not performing? How often do you see that where you file a claim and someone contacts you and wants to return the car?
I'm sorry, restate one more time. Sorry.
Yeah, I was just saying that when you file a claim, how often does that lead to actual recovery of the collateral for situation where you couldn't even contact someone who has the vehicle?
Yeah, generally, if we file a claim, we're in contact with a family member or somebody who's got control of the collateral. It'll lead to a resolution of one type or another, right? Whether that's a payment for the collateral or the surrender of the collateral, and again, establishment of that deficiency balance and ultimate claim.
Great.
Thanks.
Well, Dave, I appreciate it. We're going to move on to David Head next. Just a reminder to the group on the webinar. If you do have questions, please submit those into the question box, and we'll make sure we try to address those. Half hour left. You have 2 more speakers, but we should have time for questions. So David now is really going to focus on a follow-up to where Dave started heading, which was now it's time to litigate. David does a lot of litigation and has a lot of experience in auto loan deficiency litigation. So just at a basic level, David, what documentation is needed for litigation?
Yeah, and thank you, Scott. Dave did a good job at teeing this one up in one of his earlier comments and indicating that the documentation is critical here. Part of that suit decision that Dave was talking about, you want to know that you've got the right documents in order to pursue, and you're not just wasting time or your costs and ultimately not able to recover because you've got some faulty documentation. So yeah, this is a critical aspect of it. And so what I'm going to do is, although, again, much like what I would say on almost every one of, what I might say today is state by state will vary. I'm going to try to make it as generalized as possible. And hold on, I just dropped my sign in here. And so the first thing that I want to highlight is the most critical aspect of that is the contract itself, right? So do you have the contract? Because that will be the document that will, in any event, always be included in the litigation. It's going to outline the liability of the consumer, whoever signed off on it, the terms and conditions of the contract, as well as the repayment terms, and also defines the default. So first and foremost, do you have the contract? The next thing you need to establish in litigation is what does the balance do? If you're suing for a deficiency, there has to be a balance that's due. So transaction history, that's another item that will be critical in order to establish that balance due. Throughout the life of a loan, you're going to have anywhere from payments to costs to fees to any sort of adjustments, and that needs to be quantified on the documentation. Dave mentioned most critically the notice of repossession and sale and right to cures and deficiency letters. Again, those are critical documents that need to be in your possession if you're going to pursue litigation, because they are critical documents that we will need to be able to use to establish and secure a judgment on your behalf. The state will dictate what the forms of those documents look like. Unfortunately, they may be somewhat uniform, but in many instances they aren't. But they will outline the timing, the method of sale, and what can happen with the repossession, as well as how the sale needs to take place. And it's critical that those steps are followed, because that will lead to some bad news, and if you get too far down the road and are trying to secure a judgment. Again, that deficiency letter is critical, because that's the letter that says, hey, we sold your vehicle, here's the balance that's due, here's how we calculated that. That will sometimes be able to overcome some sort of a defense questioning that deficiency. And then finally, we talked a little bit about, both Jeremiah and Dave, about potential sale. If you are not the original holder of that loan, we need a good chain of title, a good document that shows that the loan was transferred ultimately to you. So that chain of title will be something that will be absolutely necessary as well.
So I'm curious, as we get more modern in our technology, how are attorneys and courts dealing with esign documents, whether it's online signature or obviously non-original blue ink signatures? How are you dealing with that these days?
Yeah, so that's a really good question, and it's several years ago, probably much more of a novel thing for a judge to see. Nowadays, especially over this past year, much more common, and judges are much more understanding and accepting of electronic or copied signatures, or just the blue ink originals are kind of, it's understood that not everything is done on with blue ink and on a piece of paper any longer. So that is the fortunate thing. And then the other fortunate aspect of that is the law is clear in virtually every state that I'm aware of that e-sign is just as good as a signature. So in the end, it is an enforceable signature. It creates an enforceable contract.
Great. So now we know the documentation that we need. We know we don't have to worry about the electronic world. How about venue? How about where is a lawsuit filed when it comes to an auto deficiency?
Yep, great question there. And I'm gonna get a little technical here, because we follow the Fair Debt Collection Practices Act at our firm, and any other one of your attorneys will do so. Although, you as the creditor aren't directly governed by the FDCPA, we are, and as a result of that, we need to follow those rules and when we determine where to file the lawsuit. So the FDCPA mandates that a lawsuit can only be filed in one of two places. That's one, where the contract was signed, or two, where the consumer resided at the time of at the beginning of the lawsuit. What I would say is industry practice, and I'll mention that this industry practice is most likely to suggest the venue where the consumer resided at the beginning of the lawsuit. And why, you might ask? Well, that's because at some point, assuming you are able to get your judgment, you're going to need to transfer that judgment to the venue where that consumer is residing in order to execute. So by suing them already at that venue, you've eliminated some delay and some additional costs of doing a transfer. So selecting that venue from the start is probably good and best practice. One final thing that I will mention, because most contracts do have a choice of venue clause in them, and very often these auto contracts do as well. If your lawsuit is to recover this deficiency balance, so this consumer loan, despite the fact that your contract may have a choice of venue clause, the FDCPA will trump that. And again, those two options that I just outlined are the only two places that you can proceed with litigation.
Great. So now we know where we're filing the lawsuit. As a creditor, as a client, what should they expect throughout the course of the lawsuit? What should they? Everything's about expectations. What should they expect to experience through the whole process?
Right. And again, your attorney will be the most active in the process altogether. But there are definite steps where you, as the creditor, will be asked to be involved and to provide support all the way up through from the beginning of suit filing all the way through to judgment. And so I think I'm gonna step back in order to kind of go through that and just really talk through the general lawsuit proceeding. Start very basic with the complaint, right? So initially, as I've mentioned, as Dave mentioned, documentation is going to be critical. You will need to be involved in helping to secure that documentation for your attorney in order to file that lawsuit. In addition to that, in the complaint phase, there are some states around the nation that will require a verification or an affidavit to be signed at the time the complaint was filed to be included with that complaint, so that you can validate the facts and the balances at the time of the complaint. I don't think it's a majority of the states, but there is an opportunity that as early as that point, you'll be signing off on a document. After your complaint is filed, the next step is service. So, once a lawsuit is filed, that consumer must be served before you move to any other step in the litigation process. You cannot proceed without service. The last and best known address that you can provide, or any information that you may have in order to locate the best serviceable address, is critical. So you pass that along to your attorney. Most likely you've already done that with your placement, but if for some reason you're able to locate a better address, keeping your attorney involved with that will be critical. After that complaint's been served, the consumer does, the civil rules for each state dictate a certain amount of days for the consumer to file, in this case they're now a defendant, to file an answer or some other response to the litigation. If they do not, the next step is a motion for default. Your attorney will file that motion for default. Generally, a motion seeking a default judgment will include an affidavit, and in that case, you will select a person in your organization who's authorized to sign off on and attest to the debt and affirm the balance due in front of a notary, and that will be notarized. You'll return that to the creditor, and that gets filed with the motion for default. If an answer is filed contesting the case, there are a couple of other steps where you as the creditor may be directly engaged in the process. One of those is discovery. So that's the exchange of information, whether that's through requests for production of documents or interrogatories. You'll work along with the attorney to complete those and verify those and get those responses to the defendant through your attorney. Once you get through that process, most likely there's a motion for summary judgment phase, which is an attempt to get a judgment without sort of, it's a paper judgment. You're moving for motion for summary based on fact that your attorney is going to assert there are no issues of fact or conclusions of law to be undecided. And again, an affidavit will be needed, and you'll sign off on that. There are certain instances where, of course, cases will head toward either mediation or settlement conferences. Again, you'll take part in those directly because the court or the mediation department will require someone with authority to resolve the case to be present or partake in these sort of conferences or mediation. So you may have a need to participate in those. And finally, trial, right? So that's the ultimate happens infrequently, but it does happen from time to time where a witness will be needed to testify and authenticate business records to pursue a judgment.
So I'm just curious, and this answer may be different over the last year than historically, but how often will creditors need to travel in person to a trial versus perhaps doing it remotely? How's that working these days?
Yep, very good question. And most recently, not very often. And again, some silver lining, if you can call it that, of the past year has been the move for a number of our states that we've seen, moving from the in-person to more the telephonic or Zoom sort of appearances, and that includes with our clients. Most of our clients are still on travel restrictions, and even to this day, we're asking courts to allow our clients to be able to appear remotely. So they're much more open to it now. We do have a number of courts that are still going back to the old practice of in-person, but that will also vary state to state. Some states are much more sophisticated than others.
So in the course of litigation, of course, we may get a default, and that's one path to a judgment. But we do get contested cases. What are the standard defenses you tend to encounter, and how do you deal with those defenses in the course of an auto deficiency litigation case?
Yep, good question. Good question there. So we do see some frequently used defenses. Not every case has the same number of defenses or the same asserted defenses, but in general, they fall within a small number of actual defenses that may need to be addressed. And fortunately, most of those defenses are easily overcome, again, with good, clear, proper documentation that we've already discussed a few minutes ago. Some of those defenses include the "it wasn't me" defense, that they weren't the person who signed that. Typically, that's with an auto loan, that's a little bit more difficult to make that assertion because they usually have to be somewhere to sign that. However, we do see that with co-signers who will assert that their name was either forged or they did not give their consent to be added to the loan. And then Scott, you mentioned the esign. One of the things about an esign is if it's a true esign, there may be some other additional evidence, whether it's the IP address or something else that can be used to support that, yeah, you were in fact the person who signed off on that. We've also seen the assertion of, Dave mentioned statute of limitations and suggested you give those to your attorney within 12 months. Again, a statute of limitations defense is a relatively easy defense to overcome as long as you have a clear transaction history identifying when payments are made. There's the defense that basically says, I don't know this because I no longer have the car. Again, whether that's a proper defense or not, it's one of the standard ones a pro se person will often say, that their car was already repossessed and sold and I shouldn't owe anything. And again, easily overcome by an explanation that the contract outlines how this occurs, and the deficiency establishes that this is the balance that remains due. The most tricky one, then, I think I've mentioned this already, and Dave did as well, is faulty, notice of repossession and sale. This is the one that is the more technical defense, and which means you've got to be right technically in order to proceed on that. So basically the defense is asserting that the notice of sale or the sale itself did not comply with the applicable state law requirements. And if those notices or the sale itself are faulty, that may be a complete bar against you recovering a judgment and being able to recover the balance due. Or worse, open you up to a class action sort of activity based on if that's something that happens to be a general practice for you. And then finally, I guess the defense I'll throw out there, and again, this is an easy one to overcome as long as the documentation is clear, is I owe a balance, I just don't owe that balance. And so just having that transaction history that deficiency letter really helps support that, and in the end, along with an affidavit, an easy defense to overcome.
Great. So before we move to Scott Fink, we did have a question, and maybe Dave Tomer, if you could hop back on real quick, because this is really a crossover question for Dave Tomer and for you, David Head. So if we get Dave Tomer to get back on the camera and get his microphone on. So here was the question again. I'm going to start, Dave, with you, and then perhaps you could kick it over to David for the second part. And the question was, it says, I have a national portfolio. Are you able to help me in the pre-legal and legal collections nationwide? So it's really a question of our capabilities. And Dave, maybe you could talk about the pre-legal, and David could talk about the legal side of doing a national program.
Sure, Scott. Yeah, so good question. We Weltman are licensed nationally for agency type collections, right? So with the exception of North Dakota, we're properly set up to be able to execute outbound calls and letters and so forth on as an agency effort. And then on the litigation side, and I don't know if this is where I hand it over to Dave, but
sure.
David, you want to jump on?
Yeah, sure. Not a problem. So yeah, once we get those accounts transferred from us from our agency side, yes, we have the ability nationally to handle that. Whether that's we've got a footprint ourselves of 7 states that we operate in, but we also operate a national network that can handle the other 43 states. So yeah, the ability to not only collect nationally, but operate a network nationally helps in order to kind of place that in one-stop location to handle all of your needs there.
Yeah, and I'd just like to add, Scott, that you know, our operation is bifurcated along those lines, right? So we've got a group who are specifically agency focused, and they're managed by people with agency experience and agency type collectors. And as those transition to the legal process, they move to a separate part of the operation to be taken up on the legal process. So, right. And we compete directly with you know, other collection agencies, if you will, on pure agency type paper. So,
great.
Thanks.
So thanks. You know, David had one last question that came in, and then we'll move to Scott. Was related to the statute of limitations. So I know there was a reference to statute of limitations. This question specifically is, what is the statute of limitations in Ohio? I don't know whether you can answer that, but really speak maybe a little more generically about statute of limitations issues in filing lawsuits.
Yep. Yeah, I can at least speak a little bit to Ohio, although Ohio has just changed, their law has just changed. So in general, if it's a promissory note, it's 6 years. If it's a retail installment agreement, it's 4 years. Ohio's general statute of limitations, if you're just looking at a contract in general reduced, is in the process of reducing from 8 to 6. So but in general, that will vary from state to state for sure. And that is something where the choice of law may or may not have an impact depending on that state as well.
So one more, David, for you, and I promise, Scott, we're getting to you next. But you know, the question was really a generic. You know, now that we're into the post-COVID era, as far as timeline, and I know it varies, but what's the expectation from case filing to judgment? What should a client expect? How long that typically takes?
Yeah, I would say so just take out COVID and any sort of inherent delay there. You know, from suit filing to service to a default judgment, 3 to 6 months should be. I mean, 6 months is probably about the average on that. You may have to get a service attempt or 2, so 6 months there. If it's contested, you know, it's kind of hard to predict, but you can probably expect a year on a contested case.
Great. Well, David, thank you. I appreciate that. We're going to move now to the situation where the consumer files for bankruptcy, and we got Scott Fink with us. I want to start, Scott, with a topic that came up last week that sort of bridges over to this week. Where we were talking last week about situations where a creditor inadvertently doesn't get their lien noted on the title, and you know what issues are going to happen to a creditor if that happens, and then the customer files bankruptcy.
So thank you. It's a very thorny issue for auto lenders. It's sort of the nightmare scenario. The rule of thumb here is, obviously, as an auto lender, you got 30 days to record your lien on the title. That is sort of the starting point. Now you've got your bankruptcy that intervenes. Well, it could intervene. Either they file before the 30 days is up, or the 30 days passes, they file, then you realize, oops, I don't have a lien on here. If the bankruptcy is filed within the 30 days, meaning you still have some time left, no effect at all. You go record your lien. Do not wait. Make sure it doesn't stop the clock. It doesn't reset it. You still got your 30 days. But the nightmare scenario where you fail to do it within 30 days and now bankruptcy's filed, now you've got a bankruptcy trustee who steps in and has unique powers of avoidance that are not friendly to you as an auto lender. Basically, their avoidance power, they have the ability to avoid an unperfected lien as of the date of filing of the bankruptcy. So that trustee, when the bankruptcy gets filed, is going to examine the debtor, and they're going to see, the debtor has a car, and they're going to say, can I see the title? And they're going to see either, no, there is no title for the debtor to show, or they're going to see a title and your lien is on there, but your lien versus the date of the loan seems like it's more than 30 days. Trustee's going to start asking questions, and lo and behold, they can turn around and make the argument, well, on the date that you filed, it wasn't perfected properly because it didn't get it filed within the 30 days. And the trustee has the ability at that point to avoid your lien, potentially, take the car, sell it, issue a notice to all creditors, which we're going to get to this, I think, in some of the questions about what happens when there's an asset case. But we'll signal to everyone, including you now as an unsecured creditor, to file claims. So basically, they're going to sell your car and they're going to spread that money amongst you and all the other unsecured creditors out there. It's not pleasant, and there's a lot of head scratching that goes on. The question's going to come down to, first of all, one of the big reasons this happens is you as the lender have done your part. You funded the loan. The dealer or you directly send the application timely to the state, to the BMV, and the BMV screws up, and there's a delay. Bankruptcy courts, for the most part, I'm going to say there are a few holdouts that will accept this as at least a defense that, hey, it wasn't our fault, it was the state's fault. They're not going to accept that as a defense. It is a black and white, either your lien's recorded within 30 days or it's not. Now, you could also have a situation where you have an intransigent borrower who makes it difficult for you to get the lien recorded. They fail to cooperate, they're unresponsive. If you have a situation like that, my advice is seek counsel. Definitely seek counsel, because there's a potential that we can turn this back on the debtor. You may still lose your car, mind you, and have an unsecured claim, but you also may now have a non-dischargeable claim against that borrower if they were the reason that this happened. And then finally, you've also got recourse potentially against a dealer. If there's a dealer involved with this loan and they fail to timely record it, you as the lender may have rights to go back against them for their failure to record it timely.
So again, the punchline from last week is if you do notice for some reason your lien isn't timely recorded, you got to get steps to get your lien just in case something like this happens. So let me move to a few other questions. The lender gets notice of a bankruptcy. Should a lender always file a deficiency claim in a bankruptcy case? Should they file a proof of claim in every bankruptcy case?
So the short answer is absolutely yes. There are a couple of exceptions that it's not necessarily a no. It's, as I just kind of laid out in that Chapter 7 setting, at the beginning of a Chapter 7, unlike the other bankruptcy chapters, no one is supposed to file a claim. You only file a claim if and when the trustee finds actual assets that are going to be distributed to creditors. And you will know this because you will get what's called a notice of assets or a notice of need to file proof of claim. When that happens, there will be a deadline in bold lettering on the notice that tells you when you have to get the claim filed by. If you miss that deadline, you don't get to share in any of the money. If you are a secured creditor, you don't get to share in any of that money. It's only for unsecured creditors. Chapter 13 is the other sort of most common consumer bankruptcy. Always file a claim. You got 70 days to do it. If you don't file it within 70 days, you're out. You will not share in any money. Chapter 12, same thing. And then in Chapter 11, again, I'm going to tell you my legal advice, always file a claim. However, if you are scheduled in the Chapter 11 by the debtor and you are not listed as a contingent or a disputed debt, even if you don't file a claim, you're recognized as having a valid claim and entitled to share in money. But with that being said, I always recommend our clients file claims.
Right. And then, and once a claim is filed, how is the recovery on a claim calculated in the bankruptcy? How much can the client expect to be paid?
Sure. So that really comes down to a couple of factors. On the one hand, it's how much money in total did the trustee in Chapter 7 collect? We'll start with 7. How much money were they able to collect from the debtor through selling assets of theirs, from collecting a tax refund, from going after preference claims, whatever. They find whatever they can, they create a mountain of money. And then on the other hand, you've got the notice that goes out that says all creditors file claims. Once that deadline runs, now we know that this is how much in total claims exist. You bump those up against each other. The example would be if the trustee has $60,000 of assets and there are a total of $100,000 of claims that are filed that are considered legitimate and allowed, that means it's a 60% recovery. Every creditor is going to share pro rata and get 60% of whatever their claim is. That's the simplest way I can put it. There's a little more math that goes on at the beginning where if that trustee gets 60, it's not 60 going to creditors, it's 60, but then the trustee gets their fee, there's costs of sale, there's other professionals that got hired, there may be some priority tax claims that get to scoop money before anyone else, but the simple version is pro rata with all unsecured creditors. Same percentage for everybody.
Right.
And in Chapter 13, just real quick, in a Chapter 13, the trustee's not going out and taking assets of the debtor. The debtor is presenting a plan that says, this is what I'm proposing to pay. The amount they're proposing to pay to unsecured creditors will be based on a couple of things. It'll be based on what they would have lost if they'd been in a Chapter 7, meaning non-exempt assets they can't protect. That's one number. That's the bare minimum they have to pay to their unsecured creditors. Then, if they have disposable income every month that would make that number larger, if it exceeds that, then you got to add that as well. Whatever number you come up with based on that, again, same idea. There's a set amount of money that the debtor would pay within the life of the plan to unsecured creditors. Take that, bump it up against the total number of unsecured claims. You get a percentage, and all creditors that are unsecured share pro rata in that same unsecured percentage.
Great. So we had a question, here was a question that came in related to a bankruptcy, and this is, I don't know how unique it is, but it's definitely a situation for a joint account. So you have two obligors. If one person files a Chapter 7 and the other files a Chapter 13, can you still file a proof of claim?
So yes, you can. You'll probably draw an objection from one or the other, at which time it's just a matter of explaining to the court, hey, there's these two avenues of recovery. The simple answer is, as long as you don't recover more than 100%, you can have two claims in two different cases. If we get to a situation where the Chapter 7 ends up that trustee hits the jackpot and he recovers enough to pay you in full, and you still got this Chapter 13 sitting out there, we're going to have to withdraw that claim for you in the 13 once you hit full payment. But that's I'm talking deficiency balances that are unsecured. But that's a very, very rare situation. Simple answer, you can have multiple claims and multiple bankruptcies.
And I do have a Chapter 13 question. What happens when you have two obligors, one of which only files a Chapter 13? What are your rights with respect to the non-bankrupt party, and how do you go about pursuing that person?
Great question. So Chapter 13 is unique in that they have what's called a co-debtor stay. It applies to consumer debt only. So if we're talking about a commercial debt, none of what I'm saying matters. But you've got two people on the loan, one files a 13, it's a consumer debt. You can certainly file, you should absolutely file a claim in that Chapter 13, but now you've got another borrower out there who's still liable on the deficiency judgment or deficiency balance. You can go after that other borrower, but you have to first go to the court and file what's called a motion for co-debtor relief from stay. You are basically laying out to the court that there is a debt. Not only is this bankrupt debtor liable for it, but there is another party who is not bankrupt who's liable, that the plan, the Chapter 13, does not provide for 100% payment to you, and that by keeping this stay in place, you are being prejudiced. You're being prevented from collecting the rest of your balance. That's all you got to show. Court will grant it, and then you are free to go after the non-filer. But you have to make sure you get co-debtor relief before you do that.
Great. And then just as an overview question, we're just about out of time. We have a few minutes. We could probably run over if we need to. When you're filing a claim in a bankruptcy related to an auto deficiency, similar to the lawsuit, what documentation do you as the attorney need to be able to then prepare and file the claim?
Very, very simple. I want proof that the debtor is liable on the debt, which in our world, what we're talking about today, I want a copy of the note security agreement. And B, I need to demonstrate to the court what balance is owing. Now, ideally, what I would like is that the deficiency notice that goes out that calculates out this was the balance before the sale happened, this is what was left, plus the cost of sale. Those are the two things I would like to have. If you don't have you need to have the proof in writing that they signed for the debt. If you don't have the deficiency notice, as long as you can get us a breakdown yourself, we can attach that as an itemized statement of balance, and that usually will suffice. Might draw a few questions about, hey, how did the funds get applied? But I've never had an issue with it.
Great. Well, Scott, I appreciate that. We are just about out of time. There was one other question that I wanted to make a comment on. And then Dave Tomer, maybe if you could add a comment as well. And that question related to the recent 11th Circuit ruling related to third-party vendors and sending letters. What I can say, and the question is, what are our thoughts on that ruling? What I'll add, and maybe ask Dave Tomer if he wants to add a little bit more. I've actually attended a couple of webinars on that particular topic. I know that the industry is paying great attention to it. I know there's been a lot of resources from trade organizations, from the vendor organizations that are going into that. I will not profess to be an expert on it. What I can tell you, and again, I'll let Dave comment as well, my partner, Eileen Betterman, who runs our compliance group, who is all over this, is a wealth of knowledge. And if whoever asked the question, if you want to email me directly, I can certainly put you in touch with Eileen, and she can tell you everything that she knows about what's going on. But Dave, I know you've been involved in that issue. I don't know if you have anything more you want to add to my very generic, non-commentary commentary on the question.
So from my perspective, again, you mentioned Eileen. We really are deferring to her on the legal aspects. We have not changed any of our practices regarding use of letter vendors or other vendors relative to that. We have begun discussing contingencies in the event of the wrong outcome on that case, but at this juncture, we are holding the line in BAU with our current set of vendors.
Yeah, and again, Chairman, I don't know whether you have any experience on the issue or wanted to add anything on that particular issue.
No, I think what you've said so far, it's although there was a decision that came down, it was not what we would call a final decision. It just basically said the case needs to go back and be heard on its merits, and I think there's still some opportunity for that opinion to even be overturned. So yeah, I think it's a fluid situation currently.
And Jeremiah, are you dealing with that issue at all?
No, we're not.
You don't get past that information. You just provide data. You're not getting customer data. Great.
Right.
So again, we're a little bit over 3 o'clock. I wanted to thank everybody for attending today. I wanted to thank our panelists, a wealth of knowledge, and actually a great job for getting this in within the hour that we had allocated. You have all of our information. I welcome anybody to follow up after the webinar at any time with any questions you have of any of our panelists. And again, if you want to shoot an email to me, I can get it to the right people. Remember, you will get a recording of this webinar and the first part of the webinar when we're done. And again, I really appreciate it. We aim to provide a lot of these types of webinars over time, and I think over the last year we've been able to do so, and our plan is to continue it. I hope you're able to attend and pass on the word to those in the organization. So again, thank you very much for everybody.
Thanks, everybody.
Thank you.